that the federal courts could rule on my claim because they were not barred from being addressed in federal court. But after that date, beginning on that date, and I guess and after September 1st, 1995, it would be applied going forward. But if I had filed an application for writ of habeas corpus prior to September 1st, 1995, and I came back and filed another one on or after September 1st, 1995, while the state courts would not be required and by law would be barred having the authority to consider or either grant relief unless I got over a threshold. Federal courts judges could address those claims because of what I just told you. Unless I'm getting confused somewhere, that's the way I remember it, how what I was arguing. And so, as I explained so not only did I had already addressed my client. I wasn't adding anything new. But even if I had been fell into that category, Judge Melinda Harmon would not have been barred from addressing my case because, as the Fifth Circuit has said, prior to 1995, they were not applying the abuse of the writ doctrine. So this would be my first time going back. And so, even if Texas rejected hearing my claims, the federal court could consider them in federal court. But again, I'm on making so I'm showing either way I was a winner here. Unless I'm just so rusty in my memory of how that works because it's been so long ago. But that's the way I'm remembering the issue at the time. And so she refused to address my issues. And so, here come another plane. And then by the time 2000 got here, uh, the United States Supreme Court had issued a decision in a case called Martinez versus Villarreal, I believe is the name of the case. And it said that the federal judges in that case should have ruled on those claims that president had brought and that they were not barred by the law that former President Bill Clinton had signed in 1996, I think April 24 and April 26, the E- Anti-Terrorism and Effective Death Penalty Act and the Prison Reform Litigation Act. Those were signed into law by the former President Bill Clinton, and this law substantially pretty much did what Texas law had did a year before in Texas. So federal laws were pretty much following suit. So, um, as I'm trying to remember the United States Supreme Court, so I was explaining to Judge Melinda Harmon that uh, my petition, she did not address my claims, and I was citing Slack versus McDaniel or something like that. But I can get the cases, and we could get my complaint. So, in other words, the Fifth Circuit had was authorizing people in my situation claims could be heard, and people in the Supreme Court was doing likewise. So I just simply asked Judge Melinda Harmon, just rule on, she dismissed my claims, and I'm just trying to say, Judge, and she sanctioned me. And I'm citing Barber, the Fifth Circuit, I'm citing United States Supreme Court, and she sanctioned me. She sanctioned me. And the first sanction I didn't even wasn't even informed of. But although I can't, because I don't have my papers right here to I don't have my papers right here to state the way I would state it because I don't have I don't have dates and who, what, when, where, why, and how. But it's in my memory. I knew I was acting within the law. A federal judge, she has the one. First of all, the case was closed. I followed Rule 60. I was not barred, justices of the United States Supreme Court and judges of the Fifth Circuit. I was not barred from filing a Rule 60B motion. I was not barred out of court from by her or no other judge. I could freely file my Rule 60B6 motion. I filed my Rule 60B motion for relief from a void judgment alleging all I was asking her to do was to rule on my claims that were presented to the state's highest court. They were presented. All I was asking her to do was rule on, like, for example, my post-arrest silence. My lawyer on direct appeal also raised the claim that a prior judgment would not be available for enhancement purposes, enhancing the punishment, and just rule on it. She wouldn't do it. She was leaving after I did return, and after the Texas Court of Criminal Appeals that refused or rather denied, she let one case, I believe, sit for like 2 motions to reopen. Okay, Judge, even though I never was supposed to have my case dismissed, you ordered me back to the state court to exhaust my remedy, where I did, and she still would not now she won't reopen. Now she wanted, before even that, I said, well, Judge, she was stalling, and I'm scared I'm gonna get murdered in here. So I'm saying, okay, Judge, then whatever claims that you say I didn't exhaust, then I move that they just be dismissed, and you just go ahead and rule on the claims that are exhausted. She remained silent, wouldn't do nothing. So by the time that the state courts had ruled, now my claims exhausted. So now she ruled, Whitfield has filed a motion that the court dismisses unexhausted. And I'm like, no, Judge, there's no, I don't, that's okay now. They've already ruled. She ignores that. She knows that, okay, they're exhausted. Now she wants to dismiss. You wait 2 years. Look what she's doing. She's playing games. You can see what she's doing. She's playing games. So the bottom line, she did not rule on my claims. So in my Rule 60B motion, I'm scared I'm gonna get killed in here. I'm trying to get her to rule on my post-arrest silence, rule on that void enhancement paragraph. She won't do it. Instead, she issues sanction. She wants me to go away. And so but here's another crime. The case was closed by a final judgment. So once the case is closed, the court loses jurisdiction because of the final judgment. So the only way that she could have a basis for entertaining jurisdiction is to grant the motion to reopen, to hear what I'm saying. She didn't do it. Instead, she let the case stay closed and issued sanctions on me for simply trying to get her to rule on my claims. And for this reason, she sanctioned me $750 twice. As a result of that, I couldn't buy shower shoes. I don't want to talk about the consequences in prison that I suffered, but it's for this reason that she sanctioned me, and other federal judges sanctioned me, saying that I was trying to circumvent her sanction. Well, for one reason, one judge said that I tried to circumvent her sanction by filing a new petition. I could do that because she dismissed the case. When she refused to reinstate the case after the Court of Criminal Appeals had threw me out, I'm able down. Okay, now after the Court of Criminal Appeals had ruled, I had by then been transferred to another district, to another county in the state of Texas. So federal law allows a prisoner to file an application for writ of habeas corpus either in the county where the state court conviction was occurred, or in the county, district, federal district where the prisoner is confined in custody. So by the time I refiled the petition, I was in another district, like the Eastern District of Texas. I could lawfully, or whatever district I was in, I think now, Judge Ewan Jr., so I so I could file another lawsuit. And he said I was trying to circumvent her. She did not deny my petition on the merit. She simply dismissed it for failure to exhaust state court remedy. So once they were exhausted, I had the right, and they won't dispute that. Everybody has the right to then refile. Since she wouldn't reopen it, I filed a new petition. And then I think he sanctioned me or either expressed that I was trying to circumvent it. But the bottom line is this: many other federal judges started imposing sanctions on me after Melinda Harmon imposed their monetary sanctions on me in a case that was closed, and in a case where this court, Supreme Court, said that the district court in that case judge had to rule on that man's claim, a woman's claim, and where the Fifth Circuit had said that my claims, because Texas were not regularly applying the law, that the judge could rule on my claims. And that's why I'm sanctioned. That's why I'm barred out of court. And therefore the judgments are barred. And also, the United States Attorney General was sanctioned. I sent to the Fifth Circuit in a notice of appeal or a new case just recently, uh, the case law where the United States Attorney was sanctioning an immigration case, saying that the United States Attorney General or somebody was trying to mislead the federal court, and they were arguing that the court does not have that kind of power to sanction people like that. The court's power is limited, and that so I argued that, but here's Judge. So I'm getting kind of tired. This is killing me, and uh, I'm not. So I'm asking you to not only lift those sanctions because you all have the record from the federal district court, and that you can see them on Pacer, that the judge did not have jurisdiction or authority. Judge Melinda Harmon, she didn't have jurisdiction, authority to sanction me for doing what I could lawfully do. I hadn't. She's not sanctioning me because I had filed something frivolous. She's sanctioning me because I'm telling her that all I asked her to do is just rule on my petition. She didn't rule on my claim, all my claims. If this court determined my claims for post-arrest asylums and my claims in my habeas corpus petition, they were exhausted. She was supposed to rule on it. She didn't. She mischaracterized some of my other claims. I would file pleadings to clarify what I meant. This judge is evil. She's evil. I went through hell, and I'm wore out. So, God want to just let y'all kill me, fine. But that's it. My wife did not commit child abuse. I did not commit child abuse. The very fact that we have not been heard, it's a crime. How is it that we can have a whole baby taken from us, and my wife wouldn't let her tell what happened in court? I'm not. I can't go into that. I'm not. I can't go into that. Um, this is too much. I don't know if I should send this video. So let me get your permission to send it. Let me get your permission to send this video. That's what I'll do. I'll hold this video and get your permission to send it.